In the previous lesson, we took a general introductory look at the concept of the judiciary, looking at the structural components therein. In this lesson, what I'm going to do is talk about the role of judges in this process and start to explore the kinds of things that each of the different judges at each of the different levels of governance actually does. And we'll explore this in more detail as we go on, essentially. So, like I said, we took an introduction in the previous lesson to the system of the judiciary in England and Wales. We outlined the process by which judges are appointed. So we talked about, for example, the Judicial Appointments Commission. We talked about the role of the Lord Chancellor in the appointment of judges and the changing nature of this role owing to the 2005 Constitutional Reform Act. And then we also talked about the various structures of appointment within the judicial process. This lesson is going to talk about the role of judges. Now, the type of judge that we're talking about, in fact, will depend on the role that they play within the judicial system generally. And we looked at the previous lesson, early on in the previous lesson, at some of the different delineations of judicial structures. So, for example, we took a look at the different lower inferior judges, and then we also talked about the superior judges. And what we're going to do in this lesson is essentially do the exact same thing, but instead of talking about the general structure, we will talk about the role that each of these judges plays in the judicial process itself, at each level of judicial appointment. So let's begin with inferior courts. Most of the work, the day-to-day work which is done by the inferior courts, will be essentially involving the hearing of various different cases. A county court, for example, will hear civil cases. The Crown Court will hear indictable criminal cases. Indictable criminal cases, for those of you who don't know, is just a delineation between indictable and non-indictable or summary offences, which essentially delineates between the Crown Court and the magistrates. We looked at that when we took some introductory examinations of the criminal justice system when we did criminal law. In criminal cases and in some civil cases, there will also be the presence of the jury in this process. A jury may exist, it will always exist in a criminal case, at least when we talk about indictable offences, and in some civil cases there may also be juries attached as well. The delineation that is made here is between the burdens of a case. When we look at the burdens of a case, the judge will have a legal burden, as a result of which the judge represents the trier of law. The jury has what is known as an evidential burden. They will be the trier of fact. So what this essentially means is that the role of the judge versus the jury are very, very different. The judge will direct the jury on the matters of law and will also essentially tell the jury and inform the jury, or instruct the jury, should I say, in essentially coming to the conclusion that if this is the case, that you are of the opinion of this factual analysis, for example, if you believe this factual thing to be true or to be false, then you will find for the defendant or for the prosecution. Smaller claims will be dealt with by county courts, and in the case of civil proceedings, but then when we talk about non-indictable summary offences in the case of criminal law, we have to look at magistrates' courts. Moving up slightly then, let's look at the High Court. The High Court will often have a role as well in the hearing of cases. These are known as cases at first instance, given that this is often the first time the case is being tried in a judicial setting. In some cases too, however, the High Court will hear appeals from the lower inferior courts. So, for example, the county courts or even the Crown Courts can then appeal to higher up. But for the most part, the High Court will also have a very similar role to these inferior judicial systems. They will hear cases, they will be hearing cases at first instance, but in some cases they may also hear appeals. It is only when we get to the Court of Appeal that we start to see the lack of the hearing of cases and instead looking at the adjudication of legal principles. As the name suggests, the Court of Appeal will deal with appeals which are made by lower courts. The appeals process is based on disputes relating to points of law, not relating to points of fact. So if there is a trial at a lower court level, whether it be criminal or civil, and there are the jury make a decision, but there is some discrepancies in relation to how the law is applied in a particular issue, whether that be a new area of the law, whether that be a disagreement about how a judge applied and interpreted the law. This can then go to the Court of Appeal, and the question that will be answered is whether or not the lower courts were correct in their application of the law, not their application of facts. They will operate in both criminal and civil jurisdictions, so you will see Court of Appeal decisions made from both the civil and the criminal jurisdiction. The Courts of Appeal will sit an odd number of Lord Justices of Appeal, and the reason for this is to ensure that a clear decision is made on a particular case, so there is no 50-50 splits in terms of decisions that are made. Often it is the case that it is 3 judges who will sit in the Court of Appeal and make decisions, but in some rare instances where we're talking about some quite significant pieces of case law, we may also see the sitting of 5 Lord Justices of Appeal. The final stop, if you will, at least within the domestic system, that a case can go is the last point of appeal, which is the Supreme Court. The Supreme Court, again, is a final point of appeal within the domestic legal system. And it is the point of, again, an appeals court, so it doesn't hear cases in the way that a trial jury and a trial court may do. And it is the final point of appeal within the domestic legal system. And the reason why I've said that is because there are obviously cases that can be taken to other courts outside the UK. You could go to the European Court on Human Rights, for example, or the European Court of Justice in certain cases, depending on the jurisdiction. And these may also have some kind of binding authorities onto the United Kingdom's judicial system, but that's a little bit iffy in some ways. The Supreme Court, just like the Court of Appeal, will hear cases on appeal from both criminal and civil jurisdiction. There will also be points and matters of law, again, not points and matters of fact. Most often these cases will be civil in nature. It's quite rare that we see criminal cases go all the way up to the Supreme Court. However, there are plenty of examples that we can cite. In more high-profile instances, however, the cases that are at the Supreme Court are often matters of constitutional or administrative law, such as judicial review. The most famous, arguably the most famous cases were the 2 Miller cases, which takes place in relation to Brexit and the decision made by the government to prorogue Parliament, at least in the second Miller case. This was arguably the most important case in 2019 and was definitely the most highly publicised case, one of the most highly publicised cases in all of the history of the Supreme Court, in fact. Now, the decisions made by the Supreme Court will actually create something known as binding precedent. We've talked about precedent in previous lessons, but essentially the precedent binds, therefore, onto all of the previously discussed courts and creates precedent that the lower courts can't actually override in any kind of way.